Hi, Justin King here again, and joined by an expert in wills, trusts and probate. David Orr, head of the Wills, Trust Probate Department here at Williams Thompson Solicitors. And I've come to chat to him today about why we need powers of attorney. So David, hi, how are you?
Nice to meet you.
Nice to meet you. Powers of attorney, they're something that we all should have, I hear, but can you tell me a bit more about that?
Yeah, definitely. I think power of attorney is going to be more and more relevant, I think, purely because we're all living longer, and with that comes mental illnesses. I think now it's 1 in every 3 of us will probably get a mental illness, a dementia or some kind. So a power of attorney is literally a document authorising your loved ones, friends, family, whoever it might be, to access your finances or to make decisions on your care on your behalf. But I think the best way to look at it is very much like an insurance policy. The reason I say that is because it's covering you in case the worst should happen, and the worst should happen being that we fall ill mentally or physically. And the reason it's a cover is because the alternative to not having a power of attorney, something that's called a deputyship, is a far bigger, more drawn-out application with the court. The court makes the decisions for you, not your family, in terms of who they actually appoint. And also, with the added time it takes, it also costs substantially more.
Right. Wow. So that's an interesting point. So what does it cost to do a power of attorney? Can you do one yourself?
You can do a power of attorney yourself. I mean, again, I'm going to use another analogy with this. I think all the forms are available online. There's nothing to stop you from getting the forms. The court itself, the Court of Protection or the Office of the Public Guardian that deals with these documents, they're very specific in terms of how they need the documents to be dated, to be completed. And if you make any errors, they're quite brutal in terms of keeping your court fee, because there's a court fee per application of £110, and making you start the whole thing again. So I suppose the analogy I'd use for it is very much your car servicing. I suppose a lot of people, I say to a lot of my clients when they ask this question, and I get asked it quite a lot actually, is ultimately, yes, you might be able to service your car on your own, but a lot of us would rather pay someone to do it for you.
Sure.
I think that's the best way to look at it. In terms of costs, unfortunately, depending on where you are in the country, what offers are available, whether you go to a solicitor or someone that's not a solicitor, again, you've got to be careful who you go to. Could be anywhere from sort of £300 plus for the legal fees up to, I think some parts of London are also £1,000 plus for one document. But wow. I think the lower end of that would be more realistic, right, depending on where you go. I think somewhere between 300 and 500 is probably the going rate.
Okay. And when should we think about getting one of these powers of attorney? Should everyone have one, or?
Typically, people associate power of attorneys with older age, purely because most of us think that with Alzheimer's, dementias, those sort of things, they're going to come along when we're much older. The problem is that's actually a bit of a red herring, because you or I or anyone really of any age could become incapacitated straight away. So car accidents, illnesses, whatever it might be. I think it's more relevant for the more elderly, should we say. But as I said to all my clients, I think if you can do it, once you've done it, it's done. It'll last you for your lifetime. So I think everyone should at least consider it. But I appreciate with the costs involved as well, it may be that it's something that you put off until a bit later life. And it's all associated to risk at the end of the day. The risk gets higher as you get older.
Right.
So.
Sure. So David, I understand there's 2 types of powers of attorney. Mm-hmm. They do different things. Can you explain, is one more important than the other, or what are they, or how does it all work?
I would say, there are 2 different types, very different in terms of what they do. You've got what I would call the main one, and I'm sort of loath to say which one's more important because they are both important, but I think on an everyday level, the everyday one being the financial document. The reason I say that is because ultimately it takes care of all the bills. All the assets, the house, the accounts, the investments, the bills, and ultimately for a lot of us, which is obviously relevant, where we own our own house, we're likely to be paying, or at least contributing towards our own fees. So the financial one is really the crux of the document that you need, because you need access to those funds to pay for the care, which is likely where the document is being used for.
Wow.
The other document is the health and welfare. A bit more niche, but it does relate to obviously the level of care you receive, where that care is, so where you live, to things such as what you're fed, what your medicines you're allowed to take are. again, if you see sort of on an everyday basis, it's much more narrowly focused. So when clients say to me, or if clients, put it this way, if someone said to me, I can only afford one document, for me, it's particularly where they were what I'd call a typical client of mine, so they had a house and some savings, I would say, well, the financial document is the one that's really worth its weight in gold.
Yeah.
Because in the nicest way possible, if you had you had two children, the scenario I'd use, one child's in charge of the finances, one in charge of the health and welfare. If the one for the health and welfare says, I want to put mum in a £1,000 a week care home, but the one with the finances says, no, you're getting £500 a week, then there's nothing that one can do.
Right.
So again, if you see what I mean, on a practical level, when you look at it practically, I think the financial one is probably slightly more usable on an everyday basis.
Sure. And who should you give this power to? I mean, that must be a very important decision.
It's a very important decision to make because ultimately they have the same control as you have. So in terms of, for example, they could sell your property, they'll be able to invest money as you would invest money. So you need to make sure it's someone that first and foremost you trust, and that secondly you are happy that they will do what's in your best interests rather than their own interests. And obviously the obvious choices here would be family members, children, siblings. Really though, I think you could have a situation where friends are also relevant. A lot of the times there are professionals such as myself. I act as attorney for many of my clients, purely because there's a reason behind why other people aren't suitable or indeed aren't there. And ultimately I think it's just to make sure that whoever it is, I think the main thing is that you trust their overall decision and that they will do what's best for you.
Right.
So.
And another thing that I'm interested in is if people create one of these attorneys for their financial situation, does that become effective immediately?
No, the documents very much can be used in two ways. So ultimately you have a choice how you want to use it. So for it to be usable, it needs to be registered with the court. Once it comes back registered, the document can in essence lie dormant. And you have two options then. It can only ever be used at the permission of what we call the donor, so the person giving the authority away themselves. And a lot of people find, particularly in older age, is that even though they have full capacity, they just don't want to deal with the bills. They don't want to go down the bank. They don't want to go down the post office. They want someone to do it for you. So you can use it voluntarily. So it can be, and that can be whenever you decide, once it's registered. The second option is obviously involuntary when the person themselves, the donor, no longer has capacity. And at that point, the attorneys can take over without obviously asking the donor, because at that point they need to take over because that person can't manage themselves.
So there's quite a lot of protection.
There's a lot of protection. I mean, generally speaking, it depends how you do it, where you do it. I mean, obviously the original document should always be kept somewhere safe, because obviously whoever has the original document, particularly in the hands of an attorney, it could be, there's a small risk that it could be misused. With solicitors or other professionals, they will store the document in their own safe, and as an added protection for us and for our clients, and I think with all solicitors for their clients, it won't be released to anyone but the donor unless the attorneys can come to us and show us a letter or a report from the doctor saying that person's lost capacity.
Right.
And if there's any doubt, we will definitely physically go and see the client as well. So it is all gauged to protect the person, to make sure it's not misused. And very, very rarely, I mean, we've not come across a position where it's been a situation where someone has actually abused the document. But of course, it is out there. It comes with the territory of the type of document you're doing.
Yeah.
So again, very important to choose who you appoint. Really, I think is what it comes down to.
But the message I'm hearing is you're better off with one than without one.
Much better with one than without one, because unfortunately we just don't know what's around the corner.
Sure.
And you leave yourself open if you don't have one.
Yeah. Wow. Wonderful. Well, some fantastic advice there from David from Williams Thompson about powers of attorney. So that's fantastic, and thank you for watching, and hope to again see you soon.